Welcome everyone. I'm going to give everyone a minute to log in from the waiting room and get the closed captions up and running. I know we have a lot of people registered today, so it might take a minute or two to get everyone in from the waiting room. All right, closed captions are up and running, and I'm going to put that link in the chat box for anyone who needs it or just wants to see what's happening over on the closed caption page. Welcome everyone, I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services, and I am so happy to have with us today William Pena Wells. He is a staff attorney focusing on housing at Gulfcoast Legal Services, and he is going to teach us today about how to make eviction records confidential. So for those of you who attended yesterday's webinar, that was all a lot of great information, but if all of that fails, then this is the next step to trying to help your clients keep their eviction records confidential. This is being recorded and will be posted on YouTube. And Mr. Pena Wells has also agreed to share the slides with us, so I'll send that out after the webinar. And this has also been approved for CLE credit, so I will announce that at the end. And we're going to try to take questions during the webinar. There are certain points where it's easy to stop, so we'll try to take questions as long as we don't get too many questions and get too distracted. But I'm really excited about this topic, so welcome, Mr. Pena Wells.
Thank you, Christine. I'm very happy to be here. I want to thank my CEO at Gulfcoast Legal, Tammy Greer, and the rest of the staff at Gulfcoast for giving me the opportunity to explore this area of law. I want to thank my colleagues and bosses, Robin Stover, Karen Rosenkrantz, and of course, my fantastic paralegal, Arlene, without whom our house of cards would collapse entirely. So today we're going to talk a little bit about how the eviction records can be removed from the public online docket using some of the tools that are currently available. I've used them in private practice in commercial and civil litigation. It's somewhat rare and a new field to be able to apply it to the landlord and tenant situation, but the framework is equivalent, and I'm going to be going ahead and running through some of the ways that we've done it here in Pinellas County, and hopefully you can, in your practices throughout the state, wherever you are, can adapt it to fit your own needs. Sharing screen. And okay, now basically we are going to talk a little bit about the overview today. There's some ways that the evictions usually occur, and we're going to talk about the overarching constitutional view of Florida that has a very expansive public records law. We're going to then say how that law has some built-in availabilities for making information or files confidential. And we're going to talk a bit more about how that's done, at least how we've been doing it in Pinellas County. And then there are links to the pleadings that are available, and those are the ways that we have been doing it. We'll definitely want to show some things that are happening.
Sorry to interrupt, there's some audio issues. It just got better, of course, as soon as I popped up. So it was fine during our test run, but I don't know if there's anything like a fan in the background, but hopefully it's all resolved. Sorry about that.
Well, one moment, let me see what we can do. Perhaps there's something on this end. I don't think so.
It's much better right now. I don't know what
All right, well
changed.
then we'll take what's good. We'll take what's good and go with it from there. Yeah. There are some ways that you will encounter some evictions. There are going to be situations where the landlord and tenant have a dispute over rent or any of the other issues, and the landlord files for the eviction. The case gets open, but the tenant moves out and never gets served. And the landlord will then file a voluntary dismissal, but there is no saving grace on that. The eviction is on a tenant's record, even though there were no real serious issues as far as that is concerned. The other issue would be when another scenario is that the landlord and tenant do have a dispute, the case is open, the tenant is served, and during the course of the litigation, the landlord and tenant make an agreement to deal with the case, and the landlord files a voluntary dismissal. The record is still open, and the eviction is still on the tenant's record. And of course, evictions have consequences, as most negative public records do. They can influence a landlord's decision to rent to a tenant, to charge a higher rate, to ask for any number of other conditions that are disfavorable to a tenant. And on the other side of that, the eviction can appear on a tenant's credit report, other issues causing a significant drop in the credit score. So let's see what we can do with the sound at this moment. So the Florida Constitution has a significant and broad right to public access to state records, including judicial records. So that is a constitutional mandate that really can't be undone at all, because it's the constitutional requirement, and it filters down through all the state records, including court records. But there are some ways of being able to deal with that, because we do have issues where the public records law does have some exceptions in it, and those are some of the exceptions statutorily that we're going to work on right now. The loophole in the state constitutional mechanism is found in the rules of judicial administration. There's a legitimate mechanism for going ahead and sealing court records. It's used mostly in business litigation or in other litigation where there are sensitive personal issues that the litigants don't want exposed to public scrutiny. And that is contained in the Florida Rule of Judicial Administration 2.429. And this is going to show you the entire rule here that talks about some of the issues that are important in this case. So we have a lot of these here are not really available or relevant, but they are important for us to evaluate. The most important one is part of interest would be part 9 of the rule, which talks about how confidentiality is required to avoid the substantial innocent injury to an innocent third parties, avoid substantial injury to a party by disclosure of matters protected by common law or privacy right, not generally inherent in that specific type of proceedings sought to be closed, or a much more broad and generalized established public policy in Florida or the United States Constitution, rules, or case law. So those are pretty broad in their scope. So the question becomes, what is the right of privacy not generally inherent in landlord and tenant cases? Well, it's pretty straightforward. Answer is anything that the court wants it to be. And this is where we have to, as advocates, speak for our clients in the best way possible, presenting the facts and the harm in extreme detail. Now, there are 2 ways of doing this. If the parties do, in fact, actually decide that they want to agree to go ahead and work on this, a stipulation is the simplest way. Obviously, the tenant, the landlord has some issues and some needs and wants. The landlord wants the proper move-out date, in some cases, attorney's fees and costs, and the tenant wants certainty, wants their security deposit in some cases, and also wants to make sure that this case doesn't go forward and damage their record for the rest of their lives. And the way that we can actually deal with that is talking it through and settling out the terms. Now, a lot of the individual terms that you're going to be dealing with in your cases are fact specific, what the landlord wants to get, what the tenant can give up. But there are some overarching issues that do make across the board, and are some things that need to be addressed in the stipulation. Because if the stipulation is not clear, if the documents and the orders approving the stipulation aren't clear, the clerks will not take it upon themselves to act and steal the case from the online docket. And even though the parties have agreed to it, unless it's an explicit term in the document, the clerk will not take it on themselves to overcome the standard constitutional guarantee of access to court records. Now, in the stipulation, the motion for confidentiality and the settlement stipulation, we're going to talk a little bit about that. That is the bedrock of what you would need to negotiate as advocates. If what will happen is if the parties have agreed that the case will be made confidential from the online docket, this stipulation can certainly say that. The stipulation would say all the other details that are important to your particular case, the security deposit, vacating, surrendering keys. And in the stipulation, it is important that the parties either file it as a joint motion or an unopposed motion, so that it is very clear from the outset that there's no adversarial nature and no adversarial hearing, and no hearing really should be required by the court. And one of the important things that the stipulation does say is that the stipulation should make sure that the parties agree that the clerk of court is authorized at the time of signing the stipulation to remove the docket, to move the case from the public online docket, because this can be really important because you don't want to wait for quite some time, a few days, few weeks, until the court actually enters the order. If the client has a move-out date and needs to go ahead and get another place lined up very quickly, they need to have a clean record as quickly as possible. And at least in Pinellas County, if not in other jurisdictions to be determined later, where the clerks have been accommodating and allowing the case to be temporarily removed from the public online docket until the judge actually signs the motion and order approving the stipulation and directing the clerk finally to remove the case from the online docket. And once this is signed off on, either the tenant's attorney or the landlord's attorney files the stipulation with the court. A copy of one of the model stipulations that we have used is in the materials, but obviously it will have to be adapted to your particular circumstances, as long as some of the key points directing the clerk to do some things are kept in there. And now after the stipulation is signed and filed with the court, with the clerk, the next step is for the judge to sign the motion and order approving the stipulation. Now, in the materials, you see that we've used a combined motion and order simply because the stipulation has all the terms, and the court simply approves the stipulation and directs the clerk to remove the case from the online public docket. And that particular language needs to be in the order approving the stipulation, because otherwise, absent that, it is unfortunate that the clerk will not remove the case from the online docket, and it becomes incumbent on the parties to try to undo a difficult situation, which sometimes, if the plaintiff has already filed a voluntary dismissal, becomes almost impossible to do. So, and this is a very important thing that we have learned through some of our experience. The landlord gives up the case, and the stipulation is filed. The clerk has removed it. It's going to be exceptionally hard to file any of the documents in the e-filing portal, because the case won't show up as an active case in the system. So the attorney for the landlord, the attorney for the tenant, whoever's actually filing any of the documents after the clerk has gone ahead and had the issues closed, will have some problems trying to file things. Let's see. Yes, to answer the question, to clear, if an eviction is filed, is considered on a tax record, even if a final judgment of possession is not issued. Yes. Any of the court documents that are filed in a court proceeding are in the public record under that case number and that those parties' names. So if you were to go to any of the online dockets of any of the clerks of court and type in someone's name, you would see that that case had been filed, and depending upon how extensive the court record retrieval system is, you'd be able to see the actual PDFs of the filed documents. And another question is, the Florida Rules of Judicial Administration require both a hearing and the creation of a record. Is that not so? That's what the rule says. Now, since both parties have been agreeing to the outcome, the courts, at least the courts in Pinellas County, have not been requiring a hearing and have been simply entering the orders as an unopposed matter. Now, in the fact, if it is an opposed case where the landlord is not willing to agree, and you have to show an extreme amount of harm, such as in some such in the case where the eviction was filed and dismissed before the tenant was even, then we have to see what happens with everyone there, because then you really have to show what's going on, and that you have an actual legitimate reason for asking the court to override the constitutional provisions. But as a general matter, we've been seeing that, as with most other unopposed matters, the courts have been agreeing to it. Now, obviously, the court does have the option to be able to request a hearing if they should want to learn more facts from any of the parties, but it is so far been not an option that the courts have exercised when it's an unopposed matter. Some of the
the sound got much better when you were answering the question, so I don't know if it's that you're sitting a little closer to the computer, but it finally cleared up.
All right, well, let's see what we can do now. I'll just push it a whole lot closer to me, and my face will be a whole lot larger.
That's perfect. We had one other question come through the chat. Why would the landlord consent where he has to evict the non-payer?
Well, basically, it has been a situation where it saves the attorneys and the clients time for having to litigate. At this point, it's really a fact-intensive situation because it's been you can actually offer a quicker turnout date, some issues with the security deposits. I mean, whatever tools you have to negotiate, you can try to negotiate as much as possible. The other issue is if the attorneys want to continue to litigate a case, it's usually an issue that a financial one. The landlord wants to settle the case as economically as possible. And if we can settle it, they don't really care if the tenant goes on somewhere else. So it's pretty fact intensive, and it depends on how the landlord and tenant have animosity, or they just want to see each other break the litigation down into a simple settlement. But going back to what we were saying before, it's really important to get all your documents saved before the case is closed in the public record, because even as the attorney under your e-file portal, where you would see a lot more things there, it comes out as a very rude shock to you, because you will only get a very simple screen. You'll just get this nice black and white box that says all your documents are confidential and you can't get them. And if you want to call the clerk's office to get any of them, then that's your responsibility. But they disappear pretty quickly. Opposed motions. Well, that's as far as whether they want the other landlords had that the client had an eviction case. Basically, the opposed motion is you have to basically show, but with evidence, why the client needs to have this removed. And there just becomes a question of you have to tip the scales in your client's favor with whatever facts you have. So it becomes a lot more difficult, and judges are so far that as I've been able to fathom in Pinellas County and some of the other places, are reluctant to go against the constitutional requirement that documents are going to be part of the public record constitutionally. So it's a lot more difficult, and it depends on what you can get done. Can the tenant move to have the case made confidential, regardless of the outcome of the case? Yes. The tenant can move for a motion for confidentiality, along with what we were saying before. It can happen that there are enough reasons for the tenant to go ahead and request that. So definitely you can get a motion filed and heard, and there would just be a question of skillful advocacy to show that the landlord should acquiesce in this request, but it is a burden that the landlord has to worry about in that case, because it's all on the tenant to show why. And we're running a little early now. Usually there are a lot more questions, but we can talk a little bit more about some of the unique issues of the motion. The rule of judicial administration itself has a sample motion that is available, and usually that is what you would pick and choose from if you wanted to have a contested matter, because it does cover a lot more of the issues that the judge may want to evaluate when the hearing is contested.
We've definitely had some more questions come in if you're ready for them.
Yeah. Well, let's see. Why is this of the case removed from the online docket? Well, yes, it is important, because especially if the tenant gets a move out date of the end of the month, and it's close to the end of the month, and the tenant is trying to get other landlords to apply, or and trying to get approved for residency in some of the other places. What happens is the landlords or the prospective landlords do background checks, and if the tenant checking service or whoever it is who's checking them sees that there is an eviction, they'll report it back, and it'll have negative consequences to the tenant trying to find a place right away. So the sooner you can get the eviction case wiped out from prying eyes, the better off your client is going to be. Let's see, does a third party have standing to oppose a motion to seal an unopposed motion? Yes, a third party that would have some kind of interest in the litigation might have a reason to oppose it. And in fact, in the motion, it does state that there are either third parties or no third parties that have an interest in the litigation. So you do disclose that and make that part of the a motion for confidentiality by the rule. So you would need to talk about who is there and what rights they have. How many times does someone seal their eviction? Well, as many times as the court will let them. What are the parameters that are required in your motion? Style change. I'm not really sure what that means, but basically, you request that the case be removed from the public online docket, and that's pretty much it. It stays removed unless you have some terms in the stipulation that say unless the tenant doesn't do X, Y, or Z, in which case it can go back and the landlord can go back and try to get the confidentiality removed and put it back on the public docket. Sometimes a carrot and stick that the landlord wants to make sure that they get compliance with the stipulation. Have anyone had an estimated best guess of how many eviction cases have successfully used? Well, I don't know, because basically, as far as I can tell, not to bang our own drum, but I think Gulfcoast is the one that has basically done this the most in the central area. I haven't heard of it done too very often as a routine matter, but pretty much 9 out of 10 of my cases in the past year plus have agreed one way or another to close the docket. So we have a really substantial track record in Pinellas County, which I'm hoping that everybody statewide can try to replicate in their own jurisdictions. Older evictions. Well, there you have some problems, because once a case is over, once the plaintiff has filed a voluntary dismissal, technically the case is dead. The court has no jurisdiction to do anything anymore with that, unless the parties can agree to, or the tenant can file a motion to set aside the voluntary dismissal. And those are pretty difficult to argue, and you need some pretty strong grounds to be able to make those happen. But that was one of the good things. I was hoping that we'd have some things to celebrate today, because I know House Bill 1193 that just passed its last committee yesterday and is going to second reading of the House floor did have a retroactive provision in it. But unfortunately, there doesn't seem to be much action on the Senate side. So I can't say that that'll be going much further in the last few weeks of the legislative session. So unfortunately, it is much harder to undo something than it is to work with it while we have an active eviction case. Contested motion, yes, I've done some contested motions. They are a whole lot more difficult to prove, because you have to actually try to show a significant amount of harm to the tenant. Either they got a denial based on having an eviction or something of that sort that really will overcome the broad constitutional provision that courts or records are open. Tenant could pay past due rent and attorney's fees and costs in an eviction. Yes. Well, unfortunately, or fortunately, depending upon how we look at it now, the COVID pandemic has given the blessing of CARES Act money to a lot of tenants in various programs or other, and they can be able to offer the landlords reimbursement in many cases on that. And that's one of the carrots and sticks that we have had as a negotiating tool to try to influence landlords and landlords' attorneys to accept sealing the record from public view as a condition of getting the CARES Act money. As I said, how many counties have you seen is more likely to grant these than others? Well, I don't know that, and I'd be glad to hear any information anybody else has. But from what I understand, it hasn't been done in any great degree to any other in other counties except Pinellas. So we really don't have a lot of metrics. That's what I really want to have this webinar do, which is percolate this throughout the state so we can get a lot more metrics and a lot more issues going forward. If you have any problems getting the clerk to act before an order is signed, well, I have not. In Pinellas County, the clerk has been very good about taking the agreement of the parties as a temporary measure to close the case, especially since the stipulation usually says that the parties will agree that the judge grants the motion. So there really is no serious downside for the clerk to act that way. In case of the judgment granted this motion post-judgment, how long is it? I had one case where it was a relatively short time after the voluntary dismissal, and we undid the voluntary dismissal to go ahead and get the issue heard. But as I said before, generally a voluntary dismissal acts as a stripping of the court with any kind of jurisdiction to do anything in any cases because it's not a live controversy anymore. So I have to say that that's not a situation that's happened very frequently. As I say, we can try, statewide, a lot of the people who are listening to this can try to push that envelope, but right now it's not something that I have any statistics on. Clerk's office charge a fee. No, the church office, the clerk's office doesn't charge a fee to seal it because it's not really sealing it in the sense that it's sealing or expunging criminal cases. It's simply, and that's one of the reasons why we're able to have the rule applied. We're not removing it from the public domain. We're simply taking one way it's visible out of the mix. So it's just not visible to anybody who wants to type a name into a computer and find it. So we're only limiting the access in one way. Yes, you can file cases through the portal. As I was saying before, it's a lot more of a chore because your cases don't actually come up. I'm sorry that you can't understand it. Let me try to see if we can get better sound on this.
That's better. Don't move.
All right, and there we go. In any event, all right. We had a great time in sound check. I apologize, everybody. But in any event, yes, you can file documents through the portal. You simply have to manually enter all the information. It doesn't come up as a matter of course when you have your cases there. And you'll be able to file it and get responses.
Thanks for all that information. That was a lot of questions. We have a few more in the chat if you're up to taking those too.
Absolutely, please. Let me find them. I don't see any.
It's all right. I'll read them to you. It's hard to find them in the chat. And let me know if you already answered this from the Q&A box. What are some of the most common ways you tie the facts to the right of privacy?
That is fact intensive, but basically you talk mostly about what is going on as far as how the Florida has also a right of privacy constitutionally. So the two rights sit side by side and need to be balanced out. So you make the balancing argument that this, and this, and this has problems with creating a negative impression on the clients and violating their right of personal financial privacy this way, and this way. And the constitutional right of access to documents doesn't mean that it is a constitutional right to put someone in a false light.
Okay. And you may have already answered this. What steps can an advocate take post-eviction, especially if the landlord has already obtained the judgment of eviction?
Well, as long as the case is open and there's a dialogue with the landlord or the landlord's attorney, you can at any time you can go ahead and file a stipulation and ask the court to enforce the terms of that stipulation rather than going ahead with final judgment, writ of possession. So basically, it's very simple to try to negotiate, but the details or the hard part is actually the negotiation and getting agreement.
All right. Who has standing to oppose a motion to seal the eviction record?
A party that would have some interest in the litigation would probably have standing to do that. But in the motion itself, by the rule, you do have to say that there are no parties that have any other interests in what the litigation. So it's on the movement to say that there are no parties or explain who the parties are.
Okay. This next question kind of has to do with private databases, which I know those are a problem with sealing criminal records, is that the records are still in those databases. Have you heard from clients that this process is helpful, even though landlords often use private databases in application processing, and those may have captured the case and it's beyond your power to change it?
Well, yeah, that is unfortunately a situation. And since this is a relatively new area of law that we're trying to push the envelope on, we haven't been able to really get good metrics on that. What we have gotten is that we're hoping that these services and these harvesters who use the public records won't find these information on the searches through the court databases, because if they can't find them in the public online docket, then there's nothing for them to go ahead with and put in their reports. So we're hoping to draw a line in the sand that everything going forward won't be in anybody's record, and that's how we're hoping to expand the protections for the tenants going forward.
I like that you're pushing the envelope and that you're getting good results, at least in Pinellas County. I did want to remind everyone, we've had a couple questions about the recording and the slides. Those will all be sent out tomorrow. And our speaker has also compiled some samples, some sample forms. So those will also go out tomorrow. Let me see if there's any more. Okay, just going through the chat. I think you mentioned the pending bill to expand the options for sealing tenant records, but you said it probably won't be resolved this session.
No, it's highly unlikely that anything would happen in that regard, because the House bill is going on, at least 1193. There are several different bills, and but the House bill 1193 is going on to the second reading at the floor. But there are there's no movement in any of the companion bills in the Senate. So it's highly unlikely in the last few weeks of as we're wrapping down towards the end of the session that there'll be rapid movement on that. And it's almost unheard of for the Senate to adopt the House bill as is. So I don't see a lot of movement to the finish line. I do see a whole lot of incremental movement towards accepting the idea and getting the legislature's consent to the concept. So I think it's a lot closer than it was last year or the year before. And hopefully, as we go and push for this from continuing sessions, we'll be able to get people to in the legislature to understand the long-term harm that this brings to everyone.
All right, and Alana Greer shared how to take action on the pending bill, so I just posted that in the chat. And we did have one more question come in. To prove significant harm, would you need expert testimony as to how landlords use tenant screening agencies and the impact of an eviction on the recommendation of the screening agency?
I would say that's a really good idea. If you can find that sort of testimony, it certainly would help to convince the court how important it is to preserve the tenant's record without blemishes.
Okay. And someone from Miami says they have not had any luck with this process in that area. The judges are hesitant to make the records confidential if the client has other evictions filed against the client. What do you think is the best counter argument to that point?
Well, that unfortunately it's going to be a very patchy response rate. Some places are going to agree. Some judges are not going to agree. The simplest of issues is just explaining the facts. I mean, a lot of the times the evictions have circumstances that can ameliorate the fact that it's not a situation where the tenant is just a deadbeat and doesn't want to pay. There were reasons why, and if you can establish enough of a sympathetic case for why the client should get this break, that's terrific. And usually, if the landlord and the tenant agree, it's a lot easier for the judge to go forward and give it an approval. But it's still very controversial and very a new area. And every case, every circuit will have different pluses and minuses. But I'm thinking that as we go forward and establish this as a more of a norm in landlord and tenant, the same way it's the norm in business litigation, judges will be a little less reluctant to apply it because it's not new law; it's just new application of an old law, of an old rule that's been used in a lot of situations previously.
Okay. Is it required that the landlord stipulates to make the records confidential, or have you also won cases when the landlord opposes the motion?
No, the one case that stands out right now where the landlord was just totally opposed to having anything to do with this went to hearing, and the judge sided with the landlord and the constitutionality of Florida's open records provisions were prevailing. So it is the overarching theme is that it's a difficult ask, and you really have to be creative in your litigation skills to show why the client really needs this break rather than the landlord going ahead with having an eviction on their record for life.
Mm-hmm. see. Boy, people are excited about this. They've got a lot of questions. Ah,
I'm
someone had
glad
a
to
good
answer them.
story.
And also, I have my email and my phone. If anybody after the presentation has ongoing issues or ongoing questions or wants to report back statistics plus or minus in their relative jurisdictions, I'd be glad to make myself available.
Wonderful. And we had a good news story in the chat from Lydia. Said she once had a case where a grandmother was disqualified from future public housing. She pulled out all the stops, and the opposing counsel for the housing authority had tears in her eyes when the judge granted my motion. So it's good to hear good news, and I'm glad it's working so well in Pinellas. And hopefully, this training inspires everyone to keep trying it or to start trying it in your counties. We had one last question about the distinction between removing the record from the online docket and sealing the record. Can you explain that again, what the differences are on those two processes?
Absolutely. I think when people talk about sealing and expunging, they have mostly the issues of criminal law involved, and that's not the area whatever about this. Those terms, those ways of thinking don't apply because it's not sealed and expunged in any sense of the word. We're simply taking one avenue of viewing the records, the online docket, and making that taking that away. So if you were to go to the courthouse and do this, I'm assuming that you'd probably be able to find with a little bit of effort this information. So we're really just making it a lot harder for people to find in the general public or the tenant screening services or other investigators who are just scouring the public record as a matter of course.
I love to hear about creative advocacy, especially in this area where tenants don't have a whole lot of rights. So this is great to hear. Thank you so much for sharing this statewide, and thank you for hanging in there and answering all those questions. I hope we got everyone's questions. And I did want to announce the CLE number is 2007 887 N as in Nancy. Again, that's 2007 887 N as in Nancy, and I will also put that in the chat. But thank you so much, Mr. Pena-Wells. I really appreciate you sharing this with all of us. As you can tell, there's a lot of interest in this, and I hope you inspire people to make these arguments in their own counties.
I hope so too. I mean, that we certainly need to have creative advocacy to ameliorate some of the harshness of public records for life.
Yes, it's hard to get a reset. There's no do-over button, but you're trying. Well, thank you so much. I really appreciate it. Hope everyone has a good afternoon. Take care.